MMS, we are your partner in growth.
Hello, my name is Mildred Mwanyika. I'm an advocate of the High Court of Kenya. I do practice with the firm of Mamuye Mzungu Solomon. In this podcast, we are going to be discussing about guardianship in Kenya. This is to mean the laws applicable to guardianship as well as the process of acquiring guardianship in Kenya. The laws applicable to guardianship in Kenya is the Constitution of Kenya 2010 and the Children's Act 2022. The Children's Act 2022 defines a guardian as an individual who is appointed to exercise care and control of the child either through a court order or by a deed or will of the said child. What remains constant is the subject being the child. The Children's Act of 2022 defines the child as any person who has not attained the age of majority. Any person who wishes to be appointed as a guardian of a child needs to fulfill the following elements in order to enable the court grant them the guardianship order. They need to prove to court that they are not aware of the existence of the parents of the child, or that the child has been neglected and they do not know of any person who is required to take up the responsibility of this child. They equally need to prove that they have willingly approached court to make this application without any coercion or threat from any third party. They also need to prove that they have the financial capacity to maintain the child and ensure that the child does not lack their basic necessities, which are food, shelter, clothes, and education. They also need to prove that they are able to take care of the child and provide for the child. And finally, they need to prove that they do understand what it entails having parental responsibility over a minor. As indicated earlier, we stated that a guardian may be appointed through a will by a parent. This is to mean that a parent to a minor may indicate in their will that they expect a certain individual to take up the parental responsibility of their child or their children in the event that they are deceased. This can be on a case-to-case basis, where the parent can specifically appoint the guardian to take over the role of the estate of the child until they attain the age of majority, or take up general parental responsibility of the child. Where the will provides that the guardian is to only take over and take care of the child's estate, then the said guardian is known as testamentary guardian. And this is to mean that a testamentary guardian does not have or is not required to have physical custody of the minor. Whereas a guardian who has been appointed through a will to take over the general parental responsibility of the child, they are expected to have physical custody of the child. Therefore, what happens in a situation where a parent has through a will appointed a guardian, and in the event that there is a surviving parent of the child? Then the surviving parent, jointly with the guardian, are expected to take over the parental responsibility of the child in accordance with the written will. Where the guardian has renounced their duty as an appointed guardian, the surviving parent is expected to take up the responsibility solely. The Children's Act of 2022 has specifically provided for who is eligible to apply for guardianship in Kenya. The Act provides that only a Kenyan citizen can make an application to be appointed as a guardian. Further, a duly appointed guardian cannot have the child removed from the jurisdiction of Kenya without the consent of either the parents or the courts, depending on how they did obtain these guardianship orders. The Children's Act of 2022 provide for what is termed as customary guardianship or the kinship guardianship. This is not a stranger to most of our African households, where we are accustomed to taking up parental responsibilities of our relatives' minors or even our deceased family members and take them up in our homes and assume the role of being their parents. The Children's Act of 2022 has recognized this type of guardianship as the customary guardianship, to mean that the court may appoint a guardian on an application by any person, and the court will entirely rely on the customs, culture, or tradition of a specific community to enable it issue the guardianship order to the specific applicant. Therefore, an applicant under the customary guardianship, they ought to prove that the parents of the minor are either deceased or they cannot be found. They also have to prove that they do not know of any other person who is expected to take up parental responsibility or who has already taken up parental responsibility over the child. And finally, they need to prove that the child has been neglected, and should they not take up the responsibility over the said child, then the child is bound to suffer. We have earlier indicated that an applicant ought to make an application to be appointed as a guardian on behalf of a minor. This is to mean that once the minor attains the age of majority, being 18 years, automatically the guardianship orders expires. However, the guardianship orders can be extended even after the minor has attained the age of majority. An applicant who wishes to have court extend the guardianship orders, they ought to prove to court that this particular child is of mental incapacity or physical incapacity, and also that this minor cannot manage and provide for themselves due to different circumstances. On a case-to-case basis, the court would extend the guardianship orders, which the same can equally be revoked. Revocation of guardianship orders can only be done by one, either the minor themselves, or a relative of the minor, or the spouse of the minor, in the event that upon attaining the age of majority, the minor gets married. Finally, we are going to look at the procedure for applying for guardianship in Kenya. An applicant is required to approach court with an application that is brought through an originating summon together with a supporting affidavit. They are equally required to attach a list of documents that are to prove their prayers. They are required to provide a copy of the child's birth certificate, the applicant's identification documents, which can either be the national ID or their passport. They are also required to provide a death certificate in the event that the minor's parents are deceased. Proof of financial capability is also required. And finally, in the event that the minors are ongoing children or a child, they ought to provide either school reports or any school-related document that can prove the same. Thank you very much for engaging us in this episode. In case of any question and or clarifications, do not hesitate to reach out. Thank you until next time.
We at MMS believe that movement has to be orchestrated and be engineered to fit your needs. That's why we choose to move further with you rather than let you go faster alone. MMS, we are your partner in growth. We at MMS believe that movement has to be orchestrated and be engineered to fit your needs. That's why we choose to move further with you rather than let you go faster alone. MMS, we are your partner in growth. MMS, we are your partner in growth.